In the Supreme Court of the United States, Oct. 2nd, 2022, Rowland J. Brunson, Petitioner, v. Alma S. Adams, Respondents on Petition for writ of certiorari to the United States Court of Appeals for the 10th Circuit, Petition for a writ of certiorari. Questions presented. A serious conflict exists between decisions rendered from this court and lower appeal courts, along with constitutional provisions and statutes, in deciding whether or not the trial court has jurisdiction to try the merits of this case. This case uncovers a serious national security breach that is unique and is of first impression, and due to the serious nature of this case, it involves the possible removal of a sitting president and vice president of the United States, along with members of the United States Congress, deeming them unfit from ever holding office under federal, state, county, or local governments found within the United States of America, and at the same time the trial court also has the authority to be validated by this court to authorize the swearing-in of the legal and rightful heirs for president. In addition, there are two doctrines that conflict with each other found in this case, affecting every court in this country. These doctrines are known as the doctrine of equitable maxim and the doctrine of the object principle of justice. Equitable maxim created by this court, which the lower courts used to dismiss this case, sets in direct violation of the object principle of justice, also partially created by this court and supported by other appeal courts and constitutional provisions. These conflicts call for the supervisory power of this court to resolve these conflicts, which has not, but should be, settled by this court without delay. Jurisdiction. Jurisdiction is found under 28 U.S.C.A. 1257A. Final judgments rendered by the highest court of a state may be reviewed by the Supreme Court by writ of certiorari where any right or privilege is specially set up or claimed under the statutes of the United States. Supreme Court Rule 14F provisions. Amendment I of the Constitution of the United States. Congress shall make no law respecting an establishment of religion or prohibiting the right of the people peaceably to assemble and to petition the government for a redress of grievances. Article 6 of the Constitution. This Constitution and the laws of the United States which shall be made pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby. 14th Amendment to the Constitution of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state, legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may by vote of each House remove such disability. Fifth Amendment of the United States Constitution. No person shall not be deprived of life, liberty, or property without due process of law. Ninth Amendment of the Constitution of the United States. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Article 1, Section 7 of the Constitution of Utah. No person shall be deprived of life, liberty, or property without due process of law. Article 1, Section 2 of the Constitution of Utah. All courts shall be open, which shall be administered without denial or unnecessary delay, and no person shall be barred from prosecuting or defending before any tribunal in this state by himself or counsel any civil cause to which he is a party. Statement of the case. This action is against 388 federal officers in their official capacities, which include President Joseph Robinette Biden, Jr., Vice President Kamala Harris, Speaker of the House Nancy Pelosi, and former Vice President Michael Richard Pence. Respondents. All the respondents have taken the required oath to support and defend the Constitution of the United States of America against all enemies, foreign and domestic, and as such they are liable for consequences when they violate the oath of office. Respondents were properly warned and were requested to make an investigation into a highly covert, swift, and powerful enemy, as stated below, seeking to destroy the Constitution and the United States. Respondents purposely thwarted all efforts to investigate this, whereupon this enemy was not checked or investigated. Whereupon this enemy was not checked or investigated. Therefore the respondents adhered to this enemy because of respondents' intentional refusal to investigate this enemy. Petitioner Alan J. Brunson brought this action against respondents because he was seriously personally damaged and violated by this action of respondents, and consequently this action unilaterally violated the rights of every citizen of the USA, and perhaps the rights of every person living, and all courts of law. On January 6, 2021, the 117th Congress held a proceeding and debate in Washington, D.C. Proceeding was for the purpose of counting votes under the 2020 presidential election for the President and Vice President of the United States under Amendment 12. During this proceeding, over 100 members of U.S. Congress claimed factual evidence that the said election was rigged. The refusal of the respondents to investigate this congressional claim the enemy is an act of treason and fraud by respondents. A successfully rigged election has the same end result as an act of war to place into power whom the victor wants, which in this case is Biden, who, if not stopped immediately, will continue to destroy the fundamental freedoms of Brunson and all U.S. citizens and courts of law. Due to the fact that this case represents a national security breach on an unprecedented level like never before seen, seriously damaging and violating Brunson, and coincidentally affects every citizen of the USA and courts of law. Therefore, Brunson moves this court to grant this petition, or in the alternative, without continuing further, order the trial court to grant Brunson's complaint in its fullest. Brunson's complaint is the mechanism that can immediately remove the respondents from office without leaving this country vulnerable without a president and vice president. Despite the grave importance of this case, the trial court granted respondents' motion to dismiss motion by stating it is ordered and adjudged that plaintiff Rowland Brunson's action is dismissed without prejudice. This order followed the trial court's order to adopt its report and recommendation that Brunson did not get until close to the beginning of October 2022, thus prejudicing Brunson from timely filing any objections, and the order did not properly address Brunson's opposition to the motion. Brunson's opposition clearly shows that Brunson has standing per Brunson's opening brief and as outlined in Brunson's said opposition, both not properly addressed by the lower courts. Brunson's has standing, and the trial court has full, proper jurisdiction to rule on the merits of this case based upon the following factors of the case of American Bush v. City of South Salt Lake, 2006 at 40-140 p. 3d. 1235 clearly states that the Constitution of the United States, along with state constitutions, do not grant rights to the people. These instruments measure the power of the rulers, but they do not measure the rights of the governed, and they are not the fountain of law nor the origin of the people's rights, but they have been put in place to protect their rights. Therefore, the statutes and case law cited by respondents claiming immunity from Brunson's claims in this instance are unconstitutional, and this court needs to rule in that manner. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Therefore, the purpose of the Constitution was written to protect our self-evident rights. The Constitution cannot be construed by any means by any legislative, judicial, and executive bodies, by any court of law to deny or disparage our rights. This is the supreme law of the land. This Constitution and the laws of the United States which shall be made pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby. Article 6 of the Constitution. The First Amendment of the Constitution states that Congress shall make no law prohibiting the right of the people to petition the government for a redress of grievances. Our courts have consistently held that fraud vitiates whatever it touches. Morris v. Haas, 30 to Tex. for 192-1870. Estate of Stone Cipher v. Estate of Butts, 591 SW to D.H. 106. And it is a stern but just maxim of law that fraud vitiates everything into which it enters. Veterans Service Club v. Sweeney, 252 SW to D. 25, 27 kV.1952. Radio Shack Quarry v. Comsmart, Inc., 222 SW 3D 256. Vitiate, to impair or make void, to destroy or annul, either completely or partially, the force and effect of an act or instrument. Addition 2. West's Encyclopedia of American Law. Due to the uniqueness of this case, the trial court does have proper authority to remove the respondents from their offices under 18 U.S. Code 2381, which states, "Whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States, a court adjudicating that the respondents who have taken the oath of office to be incapable of holding their offices or who have adhered to a domestic enemy means nothing without such removal of office. Under the stated factors, Brunson has an unfettered right to sue the respondents under the serious nature of his claim. No legislation can measure Brunson's right to sue them. Furthermore, Brunson's allegations against respondents adhering to a domestic enemy and committing acts of fraud are not protected by any kind of legislation of jurisdictional immunity. Essentially, acts of Congress cannot protect fraud nor protect the violation of the oath or that give aid and comfort to enemies of the United States Constitution or America as alleged in Brunson's complaint against the respondents. These are facts that cannot be overcome. Therefore, Brunson found no need to include in this petition a copy of respondents' opposition to Brunson's opening brief or any of their arguments. Nevertheless, Brunson's opening brief does touch upon respondents' immunity arguments and shows how respondents do not, nor can they, overcome Brunson's arguments as stated herein. It is an uncontestable fact that the respondents committed fraud and treason breaching our national security as factually alleged in Brunson's complaint, thus adhering to an domestic enemy that continues to breach our national security at an alarming rate on a daily basis. This national security breach is having the same end result as an act of war to place into power whom the respondents want. Brunson moves this court with its powers to order the trial court of this case to immediately grant to Brunson the damages he seeks in his complaint. This is necessary to immediately secure our national security without any further delay. Turning now to the doctrine of equitable maxim created by this court, this doctrine stands in direct conflict of the doctrine of the object principle of justice. The doctrine of the object principle of justice is couched by the supreme law of the land and sets in motion to provide our court system to be the most just, limited, highly effective, and easy to understand, and infuses our court system to be the most highly respected and dearly admired court system greater than the world has ever seen. The doctrine of equitable maxim kills this, and had the trial court been guided by the object principle of justice, this appeal would not be necessary. In addition, the doctrine of the object principle of justice stops the precarious nature of our courts. Their jobs would be much easier with less stress, and parties in court would have a strong sense on how the court is going to rule, thus promoting settlements to high degree, and as such, lawsuits and appeals would be greatly reduced. This is an absolute fact. Jurisprudence requires this court to revoke the doctrine of equitable maxim that it created and to instill the doctrine of the object principle of justice more thoroughly throughout the entire court system in America. The doctrines of equitable maxim and the object principle of justice are fully exp in a petition before this court under docket No. 18-1147. To avoid being repetitious, Brunson herein incorporates the argument found therein, as though fully stated herein, and moves this court to address the question either under this petition or docket No. 18-1147. Reasons for granting this petition. Brunson's complaint alleges fraud, violations of the oath of office, and touches on acts of treason committed by the respondents. These serious offenses need to be addressed immediately with the least amount of technical nuances of the law and legal procedures, because these offenses are flowing continually against Brunson's liberties and life, and consequently is a continual national security breach. Voting is the greatest power an individual can exercise in a republic. It is Brunson's personal voice and the way he can protect his personal constitutional protected rights in the U.S. Constitution. See 71 of the complaint. When the allegations of a rigged election came forward, the respondents had a duty under law to investigate it or be removed from office. An honest and fair election can only be supported by legal votes. This is sacred. It is the basis of our U.S. Republican form of government protected by the U.S. See the efforts made as stated in the complaint that avoided an investigation of how Biden won the election is an act of treason and an act of levying war against the U.S. Constitution, which violated Brunson's unfettered right to vote in an honest and fair election, and as such it wrongfully invalidated his vote. As a national security interest, Brunson moves this court to be swift by going beyond granting this petition. It should order the lower court to grant Brunson's complaint to avoid any further delay. Conclusion. This petition is set forth in the interest of justice in protecting Brunson's right to petition for redress of grievances against the respondents, and ensuring his right of due process against the encroachment of the doctrine of equitable maxim, and charging the respondents who failed to investigate the allegations of a rigged election by having them removed from office without further delay. Dated October 13th, 2022.